Hello, hello, hello. It's Tony McGraven coming to you from Chicago. As usual, I'm barely up. I'm sorry. It took me a second to get this put together. I had a clip sent to me. I'm told it's good. I haven't seen it. We'll see if it is. But I got a cup of coffee. It's not very long. Let's get the party started, shall we?
Sorry. I'll be right back. I left my notebook.
Grab a jar?
Yeah. Yeah, it's just a yellow page.
Yeah, I can straighten that, JP.
All right, the court is denying all of the defendant's motions.
Strong start. I'm going to open with ruling on the motion against the defendant.
So as to the issue as to the moving to suppression of the straw as being ineffective assistance of counsel, as the prosecutor accurately points out, that any issues with the chain of custody or the testing would go to the weight, not to the admissibility of the evidence. That's pursuant to People versus White, 208 Mishap 126. On that point, the court reviewed my trial notes, and there was extensive questioning about how the straw was seized, how it was handled, where it was placed. Those issues were in front of the jury, and so they were covered by the defendant. If the jury was so inclined, they could have found that any mishandling could have affected the results of the test. They did not, after being faced with that information. So that is not a grounds for ineffective assistance of counsel. It's not a grounds for directed verdict of acquittal. It's not grounds for a new trial. The independent test, the defendant's primary theory was that it was not his pipe. He insinuated that former roommate, Rosa, may have planted it in his room. But there were other statements that he may have smoked out of a pipe from somebody he didn't know, but he wasn't a snitch. He wasn't going to tell where he got it or anything like that. But his primary thrust was that this roommate must have planted it. So there was nothing in the test report that indicated that there was any abnormalities in the testing procedures, or that the substance wasn't methamphetamine. And for those reasons, the court finds that the failure to ask for an independent test is not effective assistance of counsel by any one of his prior counsel, or by this defendant once he represented himself. The issue of self-representation, the court agrees with the prosecution that I did everything I could to advise Mr. Weaver of the risk of self-representation. Followed the protocols and followed the case law for doing that. Mr. Weaver's been down this road before. He's had at least one other case that went to the Court of Appeals on the same issue. So he knew what the risks were. He's been convicted when he was his own attorney on previous occasions. And on the prior appeals, the Court of Appeals had found that the proper procedure was in fact filed. And by advised him of the risks associated with it in extensive detail. In the court's opinion, he was trying to play some cat and mouse with the court as to, I'm forcing him to do this versus I want to have an attorney. He did ultimately say that no attorney was going to handle the case the way he wanted it to be handled, to ask the questions that he wanted to do it, and that he was going to represent himself in this case. As in the other case that went up on appeal, Mr. Weaver has a history of not getting along with lawyers. He had a different lawyer, in this case, a court-appointed lawyer. That attorney was removed. He hired an attorney. Couldn't get along with that individual. Wanted to fire her and represent himself mid-trial. So it's clear from the court that the defendant knew what the risks were, been through a trial before. He did a fairly good job of asking questions and raising the points that he wanted to make during trial. The court did find at the time, and I still believe that the defendant did make a clear and unequivocal request to represent himself. As the switch occurred from represented counsel to the defendant representing himself, the court cautioned the jury that informed them that the person has the right to represent themselves, that it's right in the Constitution that they have that right, and that they should not draw any negative inference from the fact that Mr. Weaver was choosing to represent himself, and that should not factor in any way into their decision. The court, as I was giving that instruction, the jury was affirmatively nodding their head, agreeing with that instruction. As for the motion for judgment of acquittal after a jury verdict, MCL 76926 says that no judgment or verdict shall be set aside or reversed by any court in this state in any criminal case on the grounds of misdirection of the jury or improper admission or rejection of evidence or for error as to any matter of pleading or procedure unless in the opinion of the court after examination of the entire cause it shall affirmatively appear that an error complained of has resulted in a miscarriage of justice. I cannot find that this jury verdict was a miscarriage of justice. The straw that ended up testing positive for residue was found in the defendant's bedroom. He admitted that he used that room as a bedroom and that he had possessions in there. He did make statements that he was in the bedroom quite a bit. He made a statement that people are using in the house, I'm not around. He indicated that I don't use. Then he said maybe one time thing over a weekend, smoked a pipe from someone he didn't know. He said that he was not snitching on anyone. It was just a random one-time thing that he said they indicated. So certainly with the test with the pipe in his room, with the admissions that he made, in the circumstances of this case, the court cannot find that there was a miscarriage of justice. The court would deny the motion for judgment of acquittal after the jury verdict. Then as to the motion for a new trial, the grounds essentially that were alleged in the motion I guess kind of dovetail with the ineffective assistance of counsel, which the court has already addressed. I did not find that for the time that he was represented by counsel that there was any ineffective assistance of counsel, as there's a strong presumption that issues of what questions to ask, what witnesses to call, and how to handle it are matters of trial strategy for the defense counsel. And then anything that happened after that, after Mr. Weaver was his own counsel, certainly cannot claim that ineffective assistance of counsel when he was his own counsel. I've already addressed whether the verdict was against the great weight of the evidence. The court does not find that it was. So for those reasons, the court is denying the motion for the trial. I think I addressed all the issues that were raised in the motion, and I think it's appropriate now to proceed with sentencing. Prosecution and defense was the pre-sentence investigation report at the time we made available to you.
Was, Your Honor.
It was, Your Honor.
And Ms. Longoria, have you had the opportunity to read the report and discuss it with Mr. Weaver?
I have, Your Honor.
Do you have any additions, corrections, or challenges?
I do, Your Honor.
Hang on just a second. I got my PSI buried somewhere in my paperwork. All right, I've got it. You can go ahead.
Thank you, Your Honor. The first would be on the first page for the jail credit. When this was done, it was prior to Mr. Weaver, I believe prior to his bond being revoked. His bond was revoked on October 24th of 2023. And so there should be an adjustment for the jail credit to reflect that additional time.
All right, so yeah, that is correct. There is potential of him having some jail time credit. The defendant was on parole at some period in this case. It appears to the court that he was off parole from beginning on August 11, 2022 through and he was off parole then, so he get credit for the 8 days that were originally scheduled there, and then he would have credit for the time going forward since I revoked his bond, and I think the date is accurate from October 24th, 2023 to the present, so he would get credit for that time.
Thank you, Your Honor. And then on the third page, which is page 2 of the CFJ 284. In the
So page 2 of that?
Yes, it's page 2 of the CFJ 284, but the third page of the PSI. The description of the offense.
Okay.
So there is, Mr. Weaver is here for allegations of methamphetamine. In this narrative, it talks about empty beer cans and a leafy substance believed to be marijuana to be located. I would ask that that be stricken because that is irrelevant to the possession of methamphetamine charge.
Mr. Stay?
I would object to changing the narrative. It's a brief narrative. It describes why the parole agent was there and what he may be looking for.
I agree. Well, the description of the offense narrative will stay as written.
I wonder what the leafy substance could be.
And then in section, the one line about the suspected methamphetamine that was tested using TruNarc, it tested positive. In the police report, it indicates tested positive on TruNarc for fentanyl. It did not test positive through TruNarc for methamphetamine. When it was sent to the lab, it tested positive for methamphetamine.
Oh, sweet Jesus. Judge, my client was positive for fentanyl, not meth. I want the record to so reflect.
Mr. Stay, do you have any information on that?
I'm looking here. I have on page 3 of the state police report that the item tested positive for a fentanyl compound or methamphetamine.
So I think it's accurately stated.
And then I would note on the following page, I just want to, this isn't a change or a correction, but I just wanted it noted that it indicates that it was residue. That's all that was found was residue. And then where it begins the criminal justice section, it indicates there's an offense date of 1/1 of 1900. And so I don't know what, clearly that was not Mr. Weaver because he wasn't born then.
Mr. Zerb?
Yes, I'm looking, Your Honor. I don't have your explanation for it, Your Honor.
But do you have a date? Date for it?
It's probably gonna be, I can't locate it in me.
I would ask the court to put unknown.
Does the criminal history that the parties have, does it show a conviction of larceny from a building in the 14th Circuit Court for this defendant? With the disposition date of June 22nd, 1984?
I do not have that.
Your Honor, while you're at it, I would ask that the next, that was,
Hey, stop.
I'm
Let's
sorry.
take one issue at a time. We haven't finished the discussion on this one, so I'd like to kind of take it in a methodical manner.
Right, he was in the service at the time this occurred as well. He reported to me that he was in the service from 1980 to 1982. That's what I was trying to.
People don't have any evidence of that in their records. It's obviously extremely old.
All right, so we'll put the date of the offense as unknown. The court is not going to consider that larceny from a building, potential felony from 84 in any sentencing decision that the court makes. Certainly, the defendant has a record that with prior felonies that would max out his PRV 2 score. So
Yes.
it's going to impact the advisory guidelines.
The court is not scoring it.
Correct, not scoring it, not even thinking about it.
Thank you.
All right, so the next issue is Longoria.
Yes, Your Honor, and then on the next page, there's an alleged conviction from January 13th of 1980. And Mr. Weaver indicates that he knows nothing about actually anything on that page, and that he was in the service from 1980 to 1982.
Start with you, Mr. Stade. Do you have anything on his criminal history that suggests convictions which would be listed as entry 2 of 28, 3 of 28, or 4 of 28?
First conviction that I have is from 1984. 85. I do have an 84 entry as well from Grand Haven Post. No data beyond, just it was 1983. Dismissed, it says in 1984.
So you don't show the 183 burning personal property, which would have been a probation violation sentence to MDOC in 1983.
No,
Mr. Zura?
My information that's gathered from me says that he was arrested with that charge. The case was dismissed. But this information that's in the current PSI came from prior PSIs from prior sentences.
Okay, So why don't we just look at what convictions that you found as part of your PSI that are supported by Michigan Judicial Warehouse or lien, so that we can properly score the advisory guidelines. Even though there was no prior objection, I think it's one of those kind of catch-22s that was in prior PSI is correct, but at the same time, the court's under an obligation to correctly score the advisory guidelines. So I'd like to err on the side of getting it right this time. So if Mr. Weaver happens to come back for another felony in the future, that maybe we could have a corrected or accurate rendition of what his record is. So Mr. Zurich, you don't show any conviction for Mr. Weaver that would reflect the entry 1 of 28.
I do not. No, the information that I have here in front of me from Lee actually picks up the first conviction, which is documented in the PSI as 9 of 28, and everything from that entry forward is
All right, Mr. Stay, is the information that you have.
I really like, let's preserve the record for his likely future felony.
Support any of the prior convictions 1 through 8.
I believe there's one. Number 9. I have as a conviction. Out of Nuevo County.
All right, so for entry 11 of 28, which reflects the conviction of OWI second in the 60th District Court. If he doesn't have any convictions for a first, how could that entry 11 of 28 be accurate for a second OWI?
I find that's very common. That a DWLS2 will appear in the late 80s or early 90s on the lien as a prior and not show up on any other, either a lien or a driving record. I find it frequently. I don't have an explanation for it, but I can tell you that it's common. You know, I hate to adjourn this, Your Honor, but this is starting to really, I mean, I think some of these are conviction.
But that's why I always encourage prosecution and defense, if they have issues regarding the PSI, to submit the memorandums to the court. So I'm not left here sitting on the bench trying to guess what's accurate and what's not. And as we can see, it's impossible for the court to make a determination as to what Mr. Weaver's true record is, because nobody can agree upon it. There's things that make sense about having OWI second, for instance, but we have to be able to find out first there somewhere. And for instance, the January 1, 1983.
Oh, judges hate it when you don't talk ahead of time and work out obvious stuff, and they have to slog through it on the bench. Boy, it's probably their number one complaint in life.
Burning of personal property. The sheet that I have says that he was sent to prison. He'd be sentenced to MDOC.
Right.
So
We have
that's
that.
something that we should know, that he actually got sent to MDOC.
I agree. From the people's perspective, knowing that this was in a previous PSI, the people generally don't file something to say that affirmatively that these are correct. They wait for a challenge and then verify.
All right,
Otherwise,
Ms. Longoria, I'll give you 2 weeks to file a sentencing memorandum with all your challenges to the PSI, including any challenges to the history, any facts or circumstances that would support you challenging the accuracy of those. I'll give the prosecution 2 weeks after that to do everything they can and MDOC to verify it. There has to be fingerprints out there. There has to be, doesn't have to be, there could be court records that would support these convictions. And we're not talking about just one or two potential offenses that aren't attributable to this defendant. We're talking about 7 or 8 entries, which is a significant criminal history that I don't want to consider if it's not accurate. So I'm going to reset this case for sentencing again. Set it for April 9th at 9:20.
Thank you, Your Honor.
Well, there you have it. There you have it. He brings his motion that he was ineffective, which we all knew. We all knew, and every state, and I don't even do this stuff, but I can see that every state has case law on this very topic because it's the obvious argument to make. Yes, I demand to represent myself, and then preserve the argument that I suck at being an attorney. So that's why they all get admonished on it before they do it. They sort of set them up for a quasi assumption of the risk argument. So whenever these people say I want to represent myself, then the judge has a little colloquy. So you're more likely than not you really suck at being an attorney. Just you can do it. It's your constitutional right, but you know now that you're not good at it. Which is exactly what they did. This was all Lokificent's fault. I see her in there. Perfect little coffee warm up to the day. I've got to actually put pants on and go to live court now. And I'm not happy about it. Thank y'all for coming out. I appreciate it. I'll see y'all soon.